Hello, everyone. My name is Giovanni Nogales, and I'm a paralegal here at Laos Parker. Welcome to today's webinar hosted by the Texas Association for Home Care and Hospice. Today's webinar is entitled Responding to a Potential Privacy or Security Breach, Internal and External Strategies. Today's presenters are Matthew Catoe and Heidi Kocher. Matthew is a new associate with the firm. Prior to his time with us, he worked at HHS and OIG, both their investigations teams and with their Office of Counsel. He's since come back from the dark side and brought experience in anti-kickback, Stark Law, and False Claims Act compliance matters. As for Heidi, she's been in a partner with a law firm from Laos Parker. She has over 20 years of experience advising and defending healthcare clients on legal and regulatory matters affecting providers of all sizes. She is an expert in all aspects of compliance and privacy programs, including developing and deploying policies, procedures, and training. Her experience includes serving as the Chief Compliance Officer and Chief Privacy Officer, implementing the various requirements and aspects of corporate integrity agreements, and responding to and defending audits for Medicare, Medicaid, and private insurers up to the ALJ level. She received her JD from Georgetown University Law Center. She is licensed in Texas and Maryland and admitted to the U.S. Court of Federal Claims. She is certified in healthcare compliance. This is just a quick reminder. If you have any questions throughout the presentation, please feel free to type them in the chat box, and we will address as many as possible at the end of the presentation. So without further ado, I present to your speakers, Heidi Kocher and Matthew Catoe.
Thank you, Gio. Welcome everybody to today's webinar. I do have to say up front that I have come down with something, and my voice may not make it through my entire section as well. And if that's the case, Matt will take it over sooner. But we're going to divide or attempt to divide the presentation approximately in half. So as Gio said, I'm a partner with Lyles Parker and have been around the block more than once or twice. You are also fortunate to have Matt on today's webinar because Matt actually has experience with insurers dealing with HIPAA breaches. So you have quite a bit of experience on today's webinar, and we're so fortunate to have Matt with us. So today's agenda, we're basically going to look at some of the background and help you understand some of the statutes and what is going on. I'm going to briefly touch on penalties for breaches, and then we're going to talk about risk areas. We're going to define what a breach is, and then Matt will also speak some about the breach notice and content requirements, and then touch on liability insurance, cyber insurance for breaches. So with that, Gio, if you would go to slide 3, please. All right. So one of the things that we want to mention up front is that there is a difference between the state laws and the federal HIPAA laws. So HIPAA federally is generally what is in place, but in many circumstances, the state laws may have more strict provisions in them. And so therefore, the state laws may actually take precedence over federal laws. Federal laws do apply when a state law is what is called an obstacle to accomplishing the objectives of HIPAA. But just remember that the federal HIPAA law is considered a floor and not a ceiling. So if you have state laws that are more stringent, you have to follow those state laws. And we actually have that situation in Texas, where there are a number of provisions in the state law that are more stringent than in the federal law. We are going to focus mostly on federal law in this presentation, and in a couple of spots point out where Texas is more stringent than federal law. If you run into this circumstance, make sure again that when you're dealing with HIPAA, you look at Texas state law as well. All right, so next slide, please. So you have to understand that OCR, even with the change in administration, is really focusing on HIPAA. And the general feeling in Washington is that the healthcare provider community is not being sufficiently serious about complying with HIPAA. Sure, everybody complies by having a notice of privacy practices, but that's often where people stop. There are a number of spaces and places where healthcare providers have definitely fallen down on compliance. And so as background, we just need to make you sure that you understand why this is the case. So HIPAA was originally signed into law in 1996. Okay, people, next year that will be 30 years ago. Many of you have children who are younger. So just realize how long ago this is. So in 2020, we had the final privacy rule issued. In 2023, we had this HIPAA security standards issued. And again, those are over 20 years old right now. Again, some members in the audience may have kids in college who are younger than the HIPAA security rules. Because these rules have been around so long, OCR is taking the position that you really should know and should have known what is in them when you have an issue. So the security rule compliance deadline was in 2025, and then the enforcement final rule was issued in 2026 and became effective in 2026 as well. In 2009, the TAHCH Act was enacted and signed, and in 2010 they began the enforcement of TAHCH. Next slide, please. In 2013, the omnibus final rule was issued, and in 2013 it also became enforced and effective. So again, we have quite a few years where these rules have been around. One last thing to mention is in January of this year, OCR published proposed rules on enhanced measures under the HIPAA security rule. The comments closed March 7th on that. They are sorting through the comments. But let me just say that if even half of what is in the proposed rule goes into effect, you all will really need to step up your game, even more so when it comes to complying with the HIPAA security rule. Next slide, please. Okay, so again, I know this is basics, but it's very important. So who and what does HIPAA cover? So they cover what are called covered entities, which means a health plan, a health clearinghouse, or a healthcare provider who transmits any health information in an electronic form in connection with a standard transaction. So I suppose it is possible these days where a healthcare provider is not a covered entity, but that means they are doing entirely paper records, submitting claims on paper. Everything is paper. I personally do not know of any entities left like that, but I suppose it's theoretically possible. You also have hybrid entities where your business activities include both covered and non-covered functions. Again, the standard transactions, which are things like inquiring about eligibility, submitting a claim for payment, receiving payment, and so on. If you have a hybrid entity, HIPAA only applies to the covered portion of, or the covered functions portion of the entity. Now, side note here, be aware that just because HIPAA doesn't apply, it does not mean that you are scot-free. There are other rules out there that cover these kinds of things. And in particular, the Federal Trade Commission has a lot of enforcement authority over non-HIPAA related activities. So again, just beware that there's other stuff out there. And then we have the business associates. Again, the business associates provide certain functions and activities to or on behalf of covered entities that involve the use of PHI, protected health information. The HITECH Act made business associates independently and directly liable for compliance with various aspects of HIPAA. So we've got mainly the covered entities and the business associates, and you'll hear us referring to that throughout. Next slide, please. Okay, so one of the main concerns about HIPAA is always about, and particularly in the security rule, is about, oh my gosh, it is so expensive, it is so hard to comply. Well, under HIPAA, the law actually allows for what is called scalability. And what it allows you to do is it means that you don't have to do the same things as a big organization such as a hospital chain or a large national laboratory. You don't have to do the same things they are. But you do have to do minimum steps to meet with HIPAA. And one of the main problems that we see is that people view this scalability or the addressable standards, as they're called, they view those as optional. It is not optional. Just because something is scalable or addressable does not mean that the basic requirement does not have to be met. It means you have flexibility in how to meet it. So you have to be aware of what those issues are. Again, there is some flexibility under HIPAA. Again, you do not have to do what the big boys do, but you do have to meet the rules. And this really comes into play with the security factors. So HIPAA allows you to decide that if you're going to implement a particular security measure, you can evaluate the size and complexity of the organization. You can take a look at your technical infrastructure. You can look at how much it costs to implement something. And if you're doing so, you have to look at the probability of risk. So if you take those 4 factors and you evaluate them and you use that as a rationale for not doing some particular thing, that is pretty good because you've already looked at what the requirement is and then made a rational decision based on these factors about how to implement a measure to address that particular security standard. Again, remember, scalability does not mean optional. It just means, it does not mean optional for compliance. It just means you have some flexibility in how to comply. Next slide, please. The other thing you have to understand is that OCR takes patient rights under HIPAA very, very seriously. And again, the central premise here is that organizations may only release PHI as explicitly permitted by the rules or with the written consent of the individual who is the subject of the records. Moreover, when access is permitted or required, the minimum necessary standard applies. So this is something you need to keep in mind with HIPAA breaches as well. What was the information that was disclosed? Did you comply with the minimum necessary standard? So an example is always, does the front desk clerk really need access to the patient's entire medical record in the EMR? Most EMRs allow you to assign levels of access based on an individual's role. Not everybody needs blanket 100% access, so make sure you are complying with the minimum necessary as well. Next slide, please. So, Patient rights under HIPAA. They have the right to receive an appropriate privacy notice that advises them how the PHI will be used. That's pretty straightforward. Everybody complies with that. That's your notice of privacy practices. To know when and to whom there has been an disclosure. Now, under the original HIPAA, covered entities were not required to document disclosures to carry out treatment, payment, or healthcare operations. TAHCH removed that exemption, and OCR published a proposed rule in May 2011, further regulating a patient's right to an accounting of disclosures that was in the EMR. That rule has not moved forward since 2011. I think it's probably dead, but be aware that they have evaluated that. A patient has a right to request restrictions in how the provider communicates information. So, for example, a patient may say, don't leave messages on my cell phone, or leave me a voicemail message. If you leave a voicemail message containing the information the patient said not to, that is actually a breach. So this is why you need to be aware also of any restrictions on communication of information. Patient, of course, has the right to make copies of privacy notices. That's not a big deal. And a patient has the right to access their records and inspect and copy their records. Under HIPAA, this is for 6 years. You can charge reasonable fees for copying the file, but be aware that HIPAA has a lower copying charge than the state copying charge limits. And we are starting to hear more and more instances of patients becoming very aware in what their records contain and requesting access to those. There is an enforcement initiative that we'll touch on a little bit further on in the presentation. So just be aware that that's out there. And a patient has a right to amend or correct their medical records. This does not mean that they can take records out or change your comments, but they can put their comments into the file so that in their view it is a completed file. And finally, the patient has the right to complain of violations. So if they think you've had a breach and they complain, that is one of the patient rights that they have. All of these you need to be aware of because they do come up in investigations. Next slide, please. So why should you care? Again, we do have penalties. Under the HITECH Act, there is now a tiered penalty structure, which we will talk about in just a tad. Excuse me. There are now mandatory penalties for what is considered willful neglect. So let me just say that OCR did an audit, and shockingly, 84% of covered entities of healthcare providers, particularly the smaller ones, did not do a security risk analysis. 84%. That is nearly 4 out of, well, it's 4 out of 5 healthcare providers did not do a security risk analysis. That means a majority of you who are on this call probably did not do a security risk analysis. That constitutes willful neglect and subjects you to mandatory penalties if you have a breach. So if there's one thing you take away from today's webinar, make sure you do a security risk analysis. So as of 2009, OCR will now base its penalty determination on the nature and the extent of the violation and also whether or not you've corrected the violation. So again, if you have not done an SRA and you have a violation, but then you promptly go and do a security risk analysis, that helps with lowering you from the penalty tier from willful and did not address it to willful but corrected it. The penalties also depend on whether you are a first-time or repeat violators. Yes, there are repeat violators under HIPAA, and we have seen that. This is where your compliance program can help you because it is going to be persuasive to OCR if you want them to waive or reduce penalties. Just like covered entities, business associates are also now liable under this penalty structures, and also business associates cannot threaten or retaliate against anyone who files a complaint for them. Again, this triggers additional penalties. Next slide, please. So the tiers are Tier A, where the offender did not know and by exercising reasonable diligence would not have known that you violated the law. Tier B is if the violation was due to reasonable cause and not willful neglect. Tier C, the third highest or the second highest from the top, applies if the violation was due to willful neglect but was corrected. This here is where I say you will fall into this tier if you did not do an SRA but then do one promptly afterwards. And Tier D, the highest penalties apply if the violation was due to willful neglect and then was not corrected. Next slide, please. Here are the structures. So Tier 1, the minimum penalty is $141,000. It goes up to $71,000 with annual caps for 2025 at just over $2 million. Tier 2, the minimum penalty is $1,424. Tier 3, the willful neglect but fixed it within 30 days is $14,000. You can see that as a pretty significant jump. And Tier 4, the highest penalty, if there is willful neglect and not corrected, your minimum penalty is $71,000 per violation. So you want to make sure, you can see the tiers jump significantly, and you can fix a lot of these. You can get yourself into a lower tier very easily by doing what you're supposed to be doing anyway. Next slide, please. These are some recent cases. So Bryan County Ambulance Authority had just over 14,000 patients affected. They paid a penalty of $90,000. Northeast Radiology had just shy of 300,000 patients affected. They paid $350,000. The next two cases are really interesting cases. Hospice of Northern in Idaho. Again, this was a hospice. They only had 441 patients involved, which, reminder, is below the 500 cutoff where you have to immediately report it to OCR. So they only had 441 patients involved, yet they paid a $50,000 penalty. And Centara Health only had 577 patients involved. Now, Centara is a bigger entity. It has some hospitals as well as their home health. What Centara did was accidentally mail envelopes containing patient names, account numbers, and balances to the wrong addresses. They did not even have medical information in that. Centara got fined over $2 million because when OCR investigated this, Centara took the position that because those letters did not include medical information, i.e. diagnoses, treatments, pharmacy information, you name it, specifically medical information, and included only financial information, that was not PHI, and therefore they were not obligated to report. OCR came back and explicitly instructed Centara to report the breach, and Centara failed to do so. So this then became the highest tier of penalty. So you can see 577 patient records came to a $2 million fine. So OCR takes these things very, very seriously, and there are enforcement initiatives going on in relation to some of these things. So you need to take these seriously as well. Next slide, please. Matt, you want to take over, or was I going to do this one?
No, I'll take over. Sorry, I was just turning on the microphone. I'm sorry.
Yeah.
Hello, everyone. My name is Matthew Catoe. I'm going to be taking over the back half of this presentation from Ms. Heidi. We'll start off with some penalties for HIPAA privacy breaches, specifically what goes into, starting out, a civil monetary penalty related to a HIPAA breach. So when the secretary determines what goes into how much should be allocated for your civil monetary penalty fine, they're going to look at both mitigating, which means actions or actors that take away from how serious the action is, versus aggravating, which is usually, self-explanatory. Someone should have, could have, would have taken a step that was plainly obvious, or should have done something, or other actions that say this breach is worse because of someone's failure or action somewhere in the chain of events. On your screen are a series of factors that we've seen factor into these monetary penalty evaluations, including the nature and the extent of the violation, the number of individuals that were affected, as well as the time period as to where it occurred, how long was this going on, how many people got affected over the course of the breach. There's also the nature and the extent of the harm resulting from the violation, whether physical, financial, reputational, or other similar events occurred that then hinder an individual's ability to get health care. This also laterals or dovetails into privacy concerns in terms of identity theft. How many individuals now have to report credit freezes or had accounts opened in their name because private PHI was leaked to a degree enough that fraudsters could impersonate these individuals and go out for credit cards and loans in their name. There's also a history of prior compliance with the administrative simplification requirements, including prior violations. This goes back to what Heidi was saying earlier. Believe it or not, there are repeat offenders with HIPAA, and if you keep showing up on OCR's list, eventually they're going to throw the book at you. So it's better to nip most, if not all, breaches in the bud as early as possible so that you don't have this turn into an aggravating factor and don't get tagged for more money down the road. There's also the financial condition of the breaching covered entity or business associate. This plays into a number of factors. First, the OCR will look at if the financial difficulties affected the ability of the entity to comply. This does not mean you get carte blanche just because compliance efforts were outside of the budget. As Heidi mentioned earlier, federal compliance is the floor. It is the base. It is the minimum. You do not have an option not to comply, but they will take into account the scalability that we were talking about earlier. Some people can't afford more advanced procedures and protections, and OCR will at the very minimum look at that when calculating a civil monetary penalty. More importantly, however, they're going to ask if this penalty would jeopardize the ability of the covered entity to provide health care. What is the size of the entity? In more rural locations, if they put a CMP on this healthcare entity and that forces them to close doors to comply with that fine, how many people will be affected in the vacuum that then becomes? And as well as any other matter that justice requires may be considered. That's just the general catch-all language. That's just anything else that they believe to be relevant to a CMP. Next slide, please. So the primary risk areas for failure to comply with HIPAA and HITECH are currently on your screen. The first one is the most obvious. It's impermissible uses and disclosures of PHI. This is improper disclosure to entities who are not supposed to have this PHI information. It can result in both civil and criminal liability, and criminal prosecutions have included, among other things, cases where hospital employees use patient PHI to finance personal gain, or cases where a physician gave access to third parties for marketing purposes. Both of these were considered illegal and resulted in criminal prosecution. The short version being, do not give PHI to people who do not have a legitimate and documented medical reason for having that PHI. It's better to stay clear than it is to risk running afoul of that requirement. Lack of safeguards on the PHI. If you have not conducted an annual HIPAA HITECH security risk analysis, we are of the opinion you must do so immediately. This is one of the first things OCR looks for when they're doing a breach analysis. Did you have a compliance plan? Did you run a security risk analysis? Did you even bother to look as to whether the PHI entrusted to your healthcare facility was properly protected. It's one of the first questions on the door and one of the easiest ways to trip up healthcare providers who are falling down on healthcare compliance. Now, I do want to bring up lack of patient access to the PHI. While not in and of itself a breach, meaning no one got access to the records that weren't supposed to be theirs or put into their control, this is still a noticed uptick in OCR enforcement actions. Under the right of access of HIPAA, individuals have the right to see and get copies of their healthcare information from their providers and their health plans. After receiving a request for right of access, a HIPAA-covered entity has 30 days or 60 days in certain extension requirements to provide an individual or the representative with their records in a timely manner. The key takeaway here for healthcare providers is timely. You cannot sit for forever and a day on patient records. If the patient has duly authorized or otherwise proven, either it's the patient themselves or an authorized representative who is allowed to have these medical records, they are owed those records under HIPAA, and you do have to surrender full and complete copies within a timely period. We mentioned it here. Oh, I'm sorry, go ahead.
Let me just jump in and say, in Texas, it's 15 days, not 30. So just remember, again, this is where the state law is more stringent.
That's right. So just to dovetail with that, Heidi did bring up that state laws can be more stringent. We urge everyone to look at their state's timeliness requirements. The name of the game is you have a set period of time to give these people their records, assuming they have proven they are who they say they are. Don't hand them out willy-nilly, but also don't overly delay. Finally, there's the use or disclosure of more than the minimum necessary PHI. Improperly using or otherwise disclosing more than the minimum necessary PHI can lead to the imposition of the significant civil penalties that Heidi was briefly touching on earlier. You don't want to uncover or disclose any more PHI than you absolutely have to. A patient requesting their own records is a full and complete copy, but if it's another doctor or another referring physician, maybe think about, do they actually need the rest of this PHI as, kind of a foregone, I don't want to run afoul of risk compliance. Next slide, please. There are security risk analysis processes that you can undertake. There is actually a new initiative as of the OCR to increase encouragement, for want of a better term, into security risk analyses. Again, it's one of the first questions they're going to ask, and as of June 10th of this year, there were 9 settlements specifically for a failure to conduct a security risk analysis, and the penalties got all the way up to over $250,000. These are very easy and straightforward security risk analyses, and they can be conducted with the analogy that we like to use here at the firm is mowing the lawn, right? Heidi's from Texas. Several of our attorneys live in hotter southern climates, myself included in Georgia. We can mow the lawn in the heat of summer. It's possible. It's within our power. But it's really hot, and it's really annoying. And I have about 1 million other things I'd rather do than sweat and worry and weed and do all this. Just outsource. We at the firm here at Lyles Parker have resources available at your disposal. We'll be happy to help you with these security risk analyses. Please feel free to just give us a call or another qualified healthcare representative. They'd be happy to do these and just outsource it. It just makes it easier. There's also a lack of access to the patient of the PHI. Once again, this is a timeliness issue. Patients who have otherwise been duly proven to be who they say they are should get access to their records in a timely fashion. Ransomware investigations are the big ticket items. These are the ones that get really expensive very quickly. There was an 8th and a 9th settlement announced in January of this year, specifically targeting Elgon information systems and VPN solutions. Both of these entities were hit with a ransomware attack that resulted in PHI compromisation, or PHI being compromised, excuse me. Some data was exfiltrated, some was utilized, some was sold on the black market. Elgon took an $80K penalty to the teeth and subjected themselves to a 3-year monitoring agreement. The costs of compliance with that monitoring agreement they themselves have to pay for. That is now an additional business expense they have to pay for 3 years to make sure they're in compliance. VPN Solutions got off a little bit lighter. They took a $90K penalty to the teeth, but only a 1-year monitoring agreement. If and when your healthcare entity system, or your healthcare IT system, is hit with a ransomware investigation, I cannot stress to you enough, get an attorney on the phone who specializes in healthcare regulatory enforcement, like those of us here at Lyles Parker or our peers at other firms. Get a compliance team to the best of your ability on the phone and check with your insurance carrier if you're covered. Move is the name of the game in a ransomware investigation. Time is everything. Finally, there is a random audit program. OCR has restarted random audit programs with covered entities and business associates, to verify compliance with HIPAA requirements. This can mean you didn't do anything wrong and they have no reason to believe you did anything wrong, but it's Tuesday and they want to see your records. Turn them over. You do have to comply with an otherwise lawful request, and they are allowed to randomly audit you, so it behooves you to get ahead of the curve. Conduct your security risk analysis and stay ahead of it so that you can very politely wish them on their way sooner rather than later. Next slide, please. So I've been speaking a lot about the risk areas. What exactly is a breach under the HIPAA privacy rule? A breach is the acquisition, access, use, or disclosure of PHI in a manner not permitted that otherwise compromises the security or privacy of that PHI. The term breach excludes, meaning does not apply, to any unintentional acquisition, access, or use of PHI of a workforce member or person acting under the authority of a covered entity or business associate if it was made in good faith and does not result in further use or disclosure in an unauthorized manner. In simple terms, this can mean a nurse practitioner or someone who is not authorized to view these medical records or has no legitimate reason to see them or view them for any medical purpose does get access in an otherwise normal screening facility, and they pump the brakes and they say, hey, before this goes any further, I'm not supposed to have this, which means I'm not distributing it to anybody else, and they let the covered entity or business associate know. That can be qualified as an unintentional access, depending on other facts in that scenario. There's also inadvertent disclosures by a person who is authorized to access PHI at a covered entity or business associate to another person authorized to access that same PHI or organized healthcare arrangement in which the covered entity participates, and the information received as a result of that disclosure is not further used or disclosed. You'll note both of these matters have termination language, meaning the breach, such as there is one, stops. Someone says, hey, this is too much. Either it's more than the minimum, like we discussed earlier, or I don't need this, or I don't have a reason to have this PHI, and they stop the dissemination of the information. That can get you away from breach language. It won't, as a carte blanche, it requires an evaluation, but it can, and that's where we stress to be compliant. Next slide, please. Is encryption required for this PHI? Contrary to popular belief, you're not required by law to encrypt your PHI. However, the question does not become whether you're forced to or made to. It becomes whether whether it's reasonable for you to encrypt a certain set of PHI. And you need to keep in mind that if there is a potential breach through loss, theft, negligence, etc., then the OCR will be double checking your decision making. And there are proposed rules, as Heidi mentioned earlier, that mandate encryption. As of the time of this presentation, they're not yet in effect, but they are considering mandating encryption. So what this means for healthcare providers is you need to think and then think again. You don't have to encrypt all of your PHI, but do you want to explain to OCR why you didn't? There's no real right answer to that question, but it's something to consider when you're evaluating your cybersecurity and HIPAA compliance. There's always loss or theft of unsecured PHI. The HITECH Act extends the privacy provisions of HIPAA by requiring that covered entities and their business associates notify affected individuals after discovering breaches of unsecured PHI. The breach notification requirements apply only to the unsecured PHI, meaning that PHI not otherwise secured through use of technology or methodology specified by the Secretary, such as encryption or destruction, that's when you have to notify people. That's unsecured PHI. That is, there's no password, there's no encryption, there's no other destruction method that renders the paper unusable. You are required to notify. Finally, breach notifications of secured PHI. If a covered entity encrypts information in order to comply with the cybersecurity rule and later discovers a breach of that information through any means, the covered entity is not necessarily required to provide notice of breach. There are exceptions, as there always are, because it's the law, but the name of the game is encryption gets you more time to work with and may prevent a necessary disclosure. Next slide, please. So on your screen now are the risk areas for breaches. On your left are the types of breaches. The most common that we've seen so far in the firm are obviously hacking or IT incidents. These are your phishing emails, your third-party threat actors, your brute force attempts that force their way through firewalls and start getting into servers and records that they're not supposed to be in and not supposed to have access to. It's very common, these occur frequently, and they're the loss leaders, for want of a better term, in this field. Improper disposal, however, is the second one. This is where people are supposed to terminate, destroy, or otherwise you don't have to keep these records anymore for any number of reasons, and the disposal method is not proper. There's lingering files out there. Something didn't make it to the recycle bin. Something wasn't properly shredded. Some identifying PHI made it away from the bin. That can be considered a breach because it is a disclosure of PHI. Loss and unauthorized access or disclosures are your third and fourth areas respectively, and we encourage all of the audience members to look thoroughly as to whether or not there is a breach in those areas and with their disposal methods. They can occur on desktop computers, laptops, through EMR systems, as well as network servers or other portable devices. Cell phones are a big one, especially with remote employees or individuals who are working on the go or while in transit. If your portable device can access medical records and some IT billionaire genius gets access to that portable device, they can access those EMRs, and that is a breach. You need to be aware of the security settings and the encryption on your files. And then obviously paper or films usually being misplaced, left out in the open, or ending up somewhere where they're not supposed to be is also a breach area. Next slide, please. There are a few affirmative defenses available under the privacy rule. These are defenses that you have to prove or argue. Affirmative defenses are exceptions, for want of a better term, that the defense puts on and says, I may have breached HIPAA, but, and whatever that but is has to comply with one or more of the affirmative defenses accepted by HIPAA. The first is the covered entity establishes to the satisfaction of the Secretary that it didn't know about the violation, and by exercising reasonable diligence would not have known that the violation occurred. This is usually present in a lot of the higher end, more sneaky ransomware attempts, where there's a level of cyber knowledge involved, for want of a better term, where covered entities can argue, maybe successfully, maybe not, that not only did they not know, but they would have had no reason to know that the violation occurred, even doing their due diligence and processes. Now, obviously, you have to argue that and prove that to the satisfaction of the Secretary, but it's an option on the table. The other option is a violation due to reasonable cause and not willful neglect, corrected during either a 30-day period beginning on the date the liable covered entity knew, meaning you have 30 days from the date you find out to correct and finish a breach, or by exercising reasonable diligence, something you should have known about. This means you caught it doing your due diligence, even if you weren't expressly notified. Reasonable cause is defined as circumstances that would make it unreasonable for the covered entity, despite the exercise of ordinary business care and prudence, to comply with the administrative simplification provisions. The Secretary may also not impose penalties if the act is punishable as a criminal violation under Chapter 42 of the United States Code, and that establishes much higher penalties for the knowing wrongful disclosure of individually identifiable health information. I would like to point out that that last one is not a defense in the way that the other two are. The other two are, I may have breached but, and the affirmative argument is getting you out of liability in full. The last one says, no, the Secretary is not coming after you, the DOJ is, and they're threatening jail time. Consider which one you'd like to deal with when you're evaluating your compliance sphere. Next slide, please. Notice of breach to an impacted individual. The covered entity must notify impacted individuals as soon as possible, but with the hard limit of 60 days from the discovery of the breach per federal law, and within the state of Texas, 30 days from the date of notice of the breach. You are required to notify individuals if one or more scenarios like what we've discussed earlier or several other factors are at play. If you're confused, please hire someone. Please outsource this. It's much easier to get ahead of your compliance efforts and work towards it as the front end as opposed to dealing with it in the back end. Breach notice requirements must contain the following: a brief description of what happened, the date of the breach, and the date you discovered said breach, the types of unsecured PHI involved, the steps patients should take to protect themselves, what the covered entity is doing to investigate, mitigate losses, and to protect against future breaches, as well as contact procedures if there are further questions. I personally, as Heidi mentioned earlier, have worked with insurance carriers who have spearheaded these efforts through one or more coverage options. It can get complicated quick, but it is required by law. So the name of the game is, look, it's annoying, it's messy, but it gets a whole heck of a lot worse if you don't comply on the front end. Work with individuals who are trained and specialized in this knowledge. Get ahead of it as best you can. Next slide, please. Sending notice to the patient, it must take place via first-class mail to the last known address of the person, or if you know them to be deceased, whatever representative information you have on file can suffice. We recommend keeping a copy of that paper trail so that you can say, I knew or had reason to believe this individual was deceased. If a breach involves 10 or more individuals, the entity can either post a notice on their website for at least 90 days, including a toll-free number for individuals to call and check whether said notice applies to their records, or they may provide notice via a major newspaper, take an ad out in the pages, or broadcast media in the geographic areas where the impacted individuals are most likely to reside. These are taking out commercials, going to the newspapers, and each breach response is fact-specific, so we strongly recommend consulting healthcare attorneys or otherwise compliance individuals to figure out what's best for you in the situation as it arises. If a breach involves more than 500 individuals, you are required by law to notify the Secretary and the Texas Attorney General or the Attorney General of the state in which your healthcare entity resides at the same time that you notify the impacted individuals, and you must, I say again, must notify the local prominent media. This means TV, pages, and website, the full gamut. You have to get the word out by law. Notification to the Secretary for breaches of unsecured protected PHI involving less than 500 individuals. A covered entity shall, meaning required to, maintain a log or other documentation of such breaches, and no later than 60 days after the end of each calendar year, notify OCR as appropriate of any subsequent breaches related to this PHI. Next slide, please. Patients harmed due to a breach, remember we gave the definition of harm earlier in these discussions and can discuss situations of harm with fact-specific scenarios. They may receive part of the penalties levied against you under HIPAA. The HITECH Act provisions of the American Recovery and Reinvestment Act of 2009, also known as ARA, amended HIPAA's enforcement structure. Patient harm is very difficult to define, even for the most seasoned lawyers, and could ultimately encourage patients to file complaints if the harm is easy to show. HITECH requires a recommendation for methodology for distributing a percentage of civil monetary penalties to, quote, an individual who is harmed by a HIPAA violation. Section 13410C3 goes on to expand upon that and require the Secretary of Health and Human Services to establish recommendations based on the distribution of monies not later than 3 years after HITECH was passed. Finally, conversations with the Office for Civil Rights revealed that implementing regulations are currently being drafted. They are currently in the process of being put together, along with a number of the other proposed rules that Heidi mentioned earlier in this slide deck. We urge you to keep an eye on them as they develop. Next slide, please. Finally, there are criminal sanctions and retaliation. This is when it has well and truly hit the fan, because as you may or may not be aware, you can be pursued both civilly, which is for the money, as well as criminally, which means jail time for one or more individuals involved under OCR or data breaches. The DOJ is responsible for investigating potential criminal violations of HIPAA. Generally, Chapter 42 of the United States Code is the criminal enforcement provision of the administrative simplification subtitle of HIPAA, and that's what they use. That's what the letter will say. We are pursuing charges under these authorities. There are 3 levels. The first is a misdemeanor, punishable by a fine of up to $50,000 and or imprisonment of up to 1 year. This means you can get both. So be aware that just because it's a misdemeanor, they can still send you to jail and tag you for $50,000. The second level is you reach by certain aggravating factors. They change it from a misdemeanor to a felony. Subsection B2 provides for fines of up to $100,000 and or imprisonment of up to 5 years, according to the legal citation on your screen. I'll also take this point in time to remind you that criminal felonies, can have implications for licensure requirements. There are mandatory and permissive exclusions that CMS and other federal programs can use to kick you out of billing if you get tagged with a felony. So you need to take these very, very seriously, because it not only is the fines and penalties you see on your screen, but it can extend to your licensure and your background and your business beyond, depending on what exactly you get hit with and how much the DOJ or whomever else is looking to throw the book at you. The last is a third level. Under subsection B3, if the crime is with intent to sell, transfer, or otherwise use individually identifiable health information for commercial advantage, personal gain, or malicious harm, you can be tagged up to $250,000 and a prison term of up to 10 years. They get serious quick, and they have a lot of teeth. We once again strongly encourage you to reach out to healthcare regulatory professionals to help walk you through this. Don't go it alone, because the penalties get steep. Next slide, please. So some practical considerations, now that I've thrown enough doom and gloom at you to darken even the sunniest day. The first is cybersecurity insurance. As Heidi mentioned earlier, I had the privilege of working with an insurance carrier who did offer this. And we encourage you to look at your carriers and their products and see if they either offer it in the first place or if it's included as a sub-provision in what you currently have with your medical malpractice liability. Obviously, you have to weigh access, cost, and affordability when agreeing to plans with your insurance carrier. And we can't tell you what's good or bad for your company, just that it is an option that you can consider. Coverage elements are obviously at play. You need to read thoroughly what the insurance carrier is offering to cover. Some items may be covered, some maybe not, no matter how close in relation they are to one another. This plays into exclusions and coverage limitations, as well as the value and the gaps in your insurance. Are you getting as much bang for your buck as you want? Is it worth it to your organization to carry this product? What are the gaps in coverage if it falls through or you have to invoke it? These are things to consider while you're adding up the cost of running your day-to-day business operations. It's out there, but you know, we can't tell you whether a certain product is good, bad, or ugly. We just recommend you carry it, if that makes sense. Next slide, please. Accessing your coverage at the time of a breach or potential breach, you should familiarize yourself with, if you have coverage, who are you supposed to call? As I mentioned earlier, time is of the essence, especially with ransomware and more technologically inclined breaches. Who do you need to get on the phone? How do you go about doing that? And can you do so from outside a compromised system? If a threat actor is in your IT field, that means they can get to one or more computers in your system. You'll need to have an out-of-system contact somehow, some way to get in touch with your compliance team for the hit the red button moment of when it's go time. It needs to be go time. You need to familiarize yourself with who to call, what you're doing first, the role of appointed cyber experts and attorneys, as well as what your role is when a breach occurs and what you're expected to do and comply with. Next slide, please. Finally, you can mitigate and strengthen your cyber readiness after a cyber fire drill. This is composing a root cause and learning lessons, determining what happened, how can you improve from it, stepping up your HIPAA security training, making sure that all new and veteran employees are aware of what is going on in the event of a cyber breach. Embed cyber awareness into your culture. We're aware that everyone in this audience is healthcare professionals, but cyber is not going anywhere, and it's becoming more and more integrated into healthcare every day. Being aware of what is and is not okay is just good business practice and just helps you stay away from things that could cost you a lot of money, time, and headache down the road. And finally, develop and draw on your experts. That's why they're there. If they are on payroll or they're on consulting, they're there to help you build up defenses. Use them. We strongly encourage it. Next slide, please. So before we turn to questions, I do want to point out this outline is provided as general information only. It is not legal advice and should not be used as a substitute for seeking legal counsel. If you want to consult with myself, Heidi, or any other member of our firm, our contact information is on screen, but please do not use this in place of actually retaining counsel in the event they occur. And I think that takes us to questions. Gio, do we have any?
No, we do not have any questions at this time. So I think I'm just going to close out. That concludes today's webinar. So thank you guys for joining us, and thank you to our speakers, Matthew Catoe and Heidi Kocher. And everyone from today's webinar will receive copies of the presentation tomorrow via email. And if you have any further questions about today's discussion or another healthcare law issue, please feel free to reach out to the speakers or directly to Lyles Parker. Have a good Wednesday and take care.
Thanks all. Bye-bye.